The House controls its own proceedings. If somebody's going to be punished, right, for defaming someone, the House can do that, right, but not a court of law. Right? No other body can intervene. So Walsh's point is that the House controls its own proceedings, right? It is essentially judge of its own affairs. And as judge of its own affairs and controlling its own proceedings, it has the power to order the production of documents, right, from ministers of the Crown. Right? And this is a parliamentary privilege that is well documented, undeniably so. And so in keeping with the principle of parliamentary privilege and responsible government, right, opposition parties keeping the government in power in check, nothing could be excluded from parliamentary scrutiny if Parliament so decides, if the House of Commons so decides. So produce those documents, Walsh says, on December the 7th. On December the 9th, one day before the opposition motion is approved in the House, the Assistant Deputy Minister in the Department of Justice, Carolyn Kaepernick, replies to Walsh in a letter that has, I regret, the hectoring tone of a lecture. There's very little law in this letter. There's a lot of reference to so-called principle. This is also the letter that MP Derek Lee alleges is intimidating witnesses who appear before the parliamentary committee and is claiming then is an abuse of parliamentary privilege. And he's so moved in a motion that all the parties brought a couple of weeks ago, calling on the Speaker to declare Parliament's privileges abused by the government, which would then lead to a contempt motion, which I'll describe shortly. So Derek Lee has focused in on Kaepernick's letter saying that it intimidates witnesses, but that's not why I want to talk about the letter. It's not the part of the story I want to tell. Rather, the story I want to tell is the kind of narrative she provides about our parliamentary form of government. Okay? She writes, there are several basic principles, I'm quoting, in our system of parliamentary democracy that must always be borne in mind. And she reminds Walsh, counsel to the House of Commons, what these are. And she describes them as the rule of law, which is a rather opaque, general, abstract obligation. I won't bore you with the details of. Parliamentary sovereignty, responsible government, both things that Walsh certainly wants to talk about, and the separation of powers. Concerning the last, the separation of powers, she writes, each of the three constitutional branches of government, the executive, the legislative, and the judicial branches, must respect the legitimate sphere of action of the other branches. Okay? So hold that thought for a moment. Right? There are three branches, and each must respect the sphere of the other. In the letter, Kaepernick, importantly, acknowledges that there's no statutory basis for refusing the production of documents, right? So she concedes Walsh's point and pulls away, really, the legal plank that the government had been relying on all along, right? That the law precluded them from producing documents. She says, well, they're not bound. It's true. These are not the type of proceedings that these statutes have in mind. But when the government makes decisions about disclosure, it's going to be informed by the values underlying Parliament's intention in these provisions. So in deciding whether to disclose, it's going to take guidance. We've locked the doors. We're going to take guidance from those statutes, right? They're not legally obliged to follow them, but they're going to guide the discretion, right, that the government's exercising in this case. And of course, it's exercising its discretion as a member of one of the three branches of government, the executive branch, right? And so what the House of Commons has to do is defer, right, to the superior opinion of the executive branch of government. So this is an important admission. There's no legal obligation to withhold those documents, right? In fact, there's nothing to prevent the government from producing those documents, and that a motion along these lines likely would compel that production. It should, anyways. Rather, the House of Commons should respect. Right? The legislative branch should respect the executive branch. I should mention that last Thursday, the Minister of Justice stood up to reply to the motions that were brought a week or so before, calling on the Speaker to declare that parliamentary privileges had been breached, which would then give rise to a motion for contempt of the House. So the Minister of Justice stood up, Rob Nicholson. He repeated the separation of powers argument and also talked about documents that were legally available. Those are the only ones that would be produced. So despite the fact that his counsel from the Department of Justice is saying that there is no legal basis to refuse disclosure, he's still he's like he didn't get the talking points. He's still invoking the old reasons, but he's invoking new reasons too, and that is the separation of powers argument. So some of you will have discerned the problem with this, right, as wise students of parliamentary government. There is no separation of powers, right, in Canada's constitutional system. If there is any, it's between the judicial and the other political branches. Judges like to think that there's a separation of powers, that they have some tenure, independence, and the like. So, but that's not what's at issue here. Of course, what's at issue here is the separation between the executive and legislative branches, and there's no such separation, and that's because, of course, responsible government rubs entirely against the idea the legislative and executive branches are fused in the Canadian parliamentary system, not separated. So it's really interesting to me as a student of U.S. constitutional law is that this principle is drawn directly from the U.S. constitutional experience, right? And we might take it for granted because we're so absorbed by Canadian and U.S. constitutional norms and ideas. In fact, it reflects a position that might well have issued out of the George W. Bush White House, and that is steer clear, right? The executive is an independent branch, and you, Congress or court proceedings or anybody else have no authority to intervene in our operations, right? This is the idea of the unitary executive that George Bush and Dick Cheney developed, originated during the George W. Bush presidency. And of course that, well, many people consider that position untenable, but at least there's a constitutional basis for arguing that there's a separation of powers, and in the U.S. Constitution, right, the executive branch is separated out from the legislative as a means of checking the tyrannical abuse of authority that might happen out of the legislative branch, right? So you get this checking branch, the executive who can exercise a veto, right, on legislative initiatives. Of course, performs other functions like commander-in-chief of the armed forces. Somewhat like a king, right? But does not have a lawmaking authority, right? And the Americans, of course, didn't draw on the principles of responsible government in a parliamentary democracy because in 1787 it was still a nascent idea in England, right? Parliamentary democracy was still sort of early in its development, and so the framers of the U.S. Constitution wouldn't have had that model to build on at the time.